So imagine your mother dies and the house has both her name and your name on the deed. You've called it our house for 20 years. And then a lawyer reads that deed out loud, and you realize that the house is not passing to you alone. It's also being transferred to your brother, his wife, and his children. Nothing was done wrong. Nobody cheated anybody. There was just that one phrase that was never written on that deed. I am Asthana from Southern Estate Lawyers. We help Alabama families plan their estates, and we sit down with the families upon the passing of a loved one. And that's when the paperwork finally gets read closely. And this is the question that comes up. We own it together, so that means it passes to me, right? Here's how I actually answer that question. In Alabama, who gets the property upon the passing of a loved one depends entirely on how the property was titled, not on what the will says, not on what anybody intended. It depends on the words written in the deed. Most states let you assume a little, but Alabama does not. The rule lives in Alabama Code 35-4-7. Under that statute, when one joint owner dies, that owner's share doesn't automatically go to the other owner. The presumption is that it goes to the deceased owner's estate. There is, however, one exception, and that is the whole ballgame. If the deed has the magic words that say joint tenancy with right of survivorship, or utilizes other words showing that exact intention, then the decedent's share passes to the surviving owner. So survivorship in Alabama has to be in writing. It is not implied by using the word and, not implied by marriage, and not implied by both names sitting in the same line. A deed to John Doe and Jane Doe creates a tenancy in common. A deed to John Doe and Jane Doe for joint tenancy with right of survivorship creates something very different. Two deeds, almost identical, but different outcomes. Let me take the two forms one at a time. First, joint tenancy with right of survivorship. In Alabama, this form usually requires equal undivided shares. So 2 owners is 50-50. 3 owners is a 1/3 each. When one owner dies, that owner's share transfers to the surviving owner or owners. And that transfer generally happens outside of probate. The reason for this is simple. In joint tenancy with right of survivorship, the surviving owner already owned a part of the real property. The law just recognizes that now they own the whole thing. And this doesn't just apply to real estate, it can apply to bank accounts, vehicles, and other title assets as well. An important thing to note here is that the deed with right of survivorship language generally overrides whatever is in your will pertaining to that real property. So if your deed says survivorship, but your will says something else, the deed will win. Now, the other form, tenancy in common. This is what Alabama presumes when the deed is silent. It works differently in 2 ways that matter enormously. First, the shares do not have to be equal. One owner can own 70% and the other 30%. This happens often when people put in different amounts of money to purchase the property, whether it's business partners or siblings. And second, and this part gets families the most, there is no right of survivorship at all. When a tenant in common dies, that share becomes part of their estate. It passes under their will if they had a valid one, or it passes pursuant to the laws of intestate succession if they did not have a will. I want to be clear about something that people get wrong constantly. A will does not avoid probate, it directs it. That tenancy in common share still goes through the probate court either way. So the surviving tenancy in common co-owner can find themselves suddenly sharing ownership with the decedent's spouse, children, or even distant relatives, people that they never chose to be in business with. Here's what this looks like in practice. 2 adult siblings inherit their parents' land in Baldwin County, Alabama. The deed lists both names, the brothers and the sisters. There is no survivorship language anywhere on that deed. The brother passes away and his half does not go to the sister. It goes through probate to his wife and his adult children. And now they own land that has been farmed for years by his sister. Everyone in that family gets along, but that does not fix the title. A different titling choice or a will directing that property to go to the sister would have produced a very different result. Now, families ask me about tenancy by the entirety or community property all the time. It's usually because a relative from another state has mentioned it. Both are forms of married couple ownership, but neither one is available here in Alabama. Alabama does not recognize tenancy by the entirety. and it is not a community property state. But people in Alabama are not missing out. In Alabama, a properly drafted survivorship deed will reach the same outcome. The language just has to be in writing. Survivorship language is not the end of the analysis. Three Alabama specific wrinkles come up often enough that you should be aware of them. Complication one is that not all survivorship deeds are equally as strong. Alabama has two different ways of drafting a survivorship deed, and they behave differently. The first is the standard version. Property goes to the spouses as joint tenants with right of survivorship. Under Alabama law, if one joint tenant owner unilaterally sells their portion of the property, it severs the joint tenancy. It now converts into a tenancy in common, and that right of survivorship is gone. Keeping this in mind, the second version is drafted differently. Property goes to the owners as tenants in common for their lives, with a remainder to the survivor of them. Alabama courts have treated that language as creating life estates with cross contingent remainders. The practical effect of that language is that a remainder interest cannot be severed by one owner acting alone. So if owner A sells their share unilaterally, but owner B then outlives owner A, owner B could likely still take the whole property, and the buyer of owner A's share may end up with nothing. Same goal, but with different levels of protection. This is the exact kind of thing a form on a website will not walk you through. You need a lawyer. The second complication is that creditors can reach an owner's share. A judgment, a bankruptcy, or a tax lien against one co owner can attach to that co owner's fractional interest. This means that an outsider could force a court ordered sale of the entire real estate, leaving you trapped in a legal battle over a property you thought was safe. Complication number three is that older deeds follow old rules. Alabama's law on survivorship has shifted twice in the mid 20th century. Deeds signed between July of 1965 and November of 1972 fall inside a narrow window. In that window, the courts in Alabama treated survivorship as being indestructible, meaning it could not be severed without everybody's consent. If your chain of title reaches that far back, that deed needs a closer look. Here's a mistake I see often on this topic. People assume that the title already does what they want. They've called the house joint for over 30 years, so they stop thinking about it. And no one reads the deed until someone dies. And by then, the options are limited or gone. So if your goal is to keep a jointly held asset out of probate, don't assume. Pull the deed, pull the account paperwork, and read the actual words. And don't stop at the house. A bank account with a payable on death beneficiary passes to that beneficiary no matter what your will says. Real estate with survivorship language behaves the same way. Your will never touches either one. The word joint does not mean the same thing across your house, your car, or your accounts. You have to check that asset by asset. So, how do you decide which form is right for you? There is no single right answer here for every family. Survivorship is a good fit for married couples who want a clean, automatic transfer of ownership. Tenancy in common is often the right call where owners contribute unequal amounts, or where someone wants to control where their share goes. And sometimes a trust can be a better tool than either one. The goal is not to pick an option that sounds best in a video. Instead, it's important to make an informed decision instead of guessing. And the worst option is what most families accidentally choose, and that is to do nothing, and hoping the paperwork already does what they want done. If you will take one thing from this video, take this. In Alabama, the deed decides, and a deed can be reviewed in an afternoon, but untangling a title upon death can take a year or more. Bring us your deeds, your account statements, and your beneficiary forms. We will review them with you in plain English and tell you exactly what happens to each of them under Alabama law. And if it doesn't reflect your true wishes, we will explain to you what it would take to fix it. This does not have to be a guess, so call Southern Estate Lawyers for your free consultation, and we look forward to working for you.